In my painting of the Peterstown grain elevator, I was going to add a siding track that ran right up to the side of the elevator. There had to be one, right? Well, no, there really wasn't. I researched and couldn't find any photos of any side track next to the elevator. Then I stumbled upon information in the, you could say, the basement of the internet about a lawsuit the Peterstown Elevator Company had against the Chicago, Milwaukee, and St. Paul Railroad concerning a sidetrack. Well, the lawsuit kind of went like this. Railroad and Warehouse Commission on relation of Peterstown Farmers Elevator and Supply Company versus Chicago, Milwaukee, and St. Paul Railway Company. Complaint of refusal to build sidetrack connection to elevator at Peterstown, Illinois, filed January 16, 1912. Appearances are for complainant J. A. Lamberton, attorney, Mendota, Illinois. For the defendant, O. W. Dines, Commerce Counsel, and J. N. Davis, attorney. Case heard February 8, 1912. Findings of commission entered April 11, 1912 as follows. The petitioner herein is a corporation newly organized under the laws of the state of Illinois, and the petition requests that an order be made requiring the Chicago, Milwaukee, and St. Paul Railway Company to build a switch track at Peterstown, County of LaSalle, State of Illinois. The petition states that the petitioner desires to build an elevator for the purpose of storing and shipping grain on and over the Chicago, Milwaukee, and St. Paul Railway, and asks that the said railroad be required to build a switch for the purpose of accommodating such elevator when so erected and ready to transact the business of shipping grain therefrom. The record shows that no elevator has been erected, but is simply in contemplation. The record also shows that the railroad company declined to build a switch as petitioned for. The statute under which this proceeding is begun reads as follows, quote, any railroad being a common carrier of freight upon application of any shipper tendering or receiving freight or merchandise in carload lots shall construct, maintain, and operate upon reasonable terms upon its own right-of-way at any regular station a switch connection with any shipper's railroad track, which may be constructed to connect with its railroad upon its right-of-way where such connection is reasonably practicable and can be put in with safety and will furnish sufficient revenue business to such railroad company to justify the construction and maintenance of the same, and shall furnish cars for the movement of such traffic upon such switch upon its own rails to the best of its ability, without discrimination in favor of or against any such shipper, unquote. It will be noted that the language of this statute, which requires the building of a switch, states, quote, at any regular station, unquote. The record shows that Peterstown is not a regular station and therefore does not fall within the purview of that statute. The record further shows that it is not a village or incorporated town, and the statute in relation to depots and switches refers to incorporated villages or towns. The record shows that the application herein is for a switch to be connected with the main line of the Chicago, Milwaukee, and St. Paul Railway. As a matter of common knowledge, every switch or every connection of any kind with the main line of a railroad increases the danger of operating such road, and it is the policy not only of this commission, but of all commissions nowadays, to limit the connections to main lines to such places and for such purposes as are absolutely necessary. The statute further provides that such application may only be made when the elevator is in existence and grain or other freight is offered for shipment in carload lots under proper conditions to such railroad. The record further shows in this case that Peterstown is only 3 and a fraction miles from Mendota, and that it is 2 8/10 miles from Fitchmore, Mendota being the first station north of the proposed sidetrack, and Fitchmore the first station south. This undisputed fact clearly indicates that the petitioner is reasonably well situated to places for the shipment of grain, or the erection of an elevator at a regular station, if it desired to do so. The record in this case further shows that there are switches and connections with said railroad for the purpose of switching grain at points named and at several other points within a few miles of Peterstown. Without going into details, it is sufficient to say that as we construe the law, the Commission has no power or authority to order a switch at this point under the facts as shown in this record. The prayer of the petition will therefore have to be denied. Prayer of petition denied. By order of the Commission this 11th day of April 1912, dated at Springfield, Illinois.